Hello everyone, I'm hoping you all are good and fine. So first of all, please let me know in the chat box is everything is perfect. If yes, then today we are going to start our most important session, that is your practice set questions of your SEBI Grade A Legal Officer batch. Yes, the session is very quite important from an exam point of view, and we will cover each and everything in a very detailed manner. But first of all, before starting this session, I want your confirmation. So just give me the confirmation in the chat box is everything is perfect, everything is fine. If yes, then I can start the session. As you know very well that we have a very less time period, and within this time period we all are required to practice lots of the important question that is from the exam point of view. Yes, so today session is why is it important? The reason is very clear. I will going to cover your most important MCQs and the questions that is totally be based upon your concepts. Yes, you know very well the contract law have a very big role in our SEBI Grade A Phase 1 examination, and that's the reason behind it. We will cover lots of the important practice set question in this session. So guys, the session is very important. I request to all of you, please do like the session as well as share with your colleagues and your friends so that they can also practice the high standard of the questions that will meet the SEBI requirement. Now, this session is based upon totally your phase 1 MCQs. Phase 1 MCQs under the paper number 2. We will practice lots of important questions. The session is very important. So, I request to like the session, share with your colleagues and bankers. And as well as subscribe the channel as well. Now you know very well that we have the Oliveboard application. So if you still don't download the specifically Oliveboard app, so I request to all of you, please download the application of Oliveboard as well. Now before moving ahead, for those aspirants who didn't know me, myself Chartered Ajay Thakral, more than 7 years of teaching experience, where I basically mentor in more than 10 of the categories. Yes, in more than 10 of the verticals I have the experience like Chartered Accountant, Company Secretary, JAP, CAP, Regulatory, SEBI. These are the category where I mentor more than 3 lakh plus aspirants. I have the best educator award for the 2 times best presenter award, and definitely best presenter award in the POSH and the POXO. Now the most important, this is your SEBI phase 1 paper number 2, and today we will going to cover the contract law, Indian Contract Law, Sales of Goods Act, Indian Partnership Act and the Special Relief Act. These all the contract law unit we will going to cover in this session. And in your phase 1 paper number 2, these all the units have the weightage of at least 25%. So we will spend a sufficient time in this session, and tomorrow onward we will cover the remaining concepts practice as well. So this is your SEBI Grade A complete course. If you have not been enrolled, you can enroll for your conceptual clarity, and this is your official Telegram channel. In case you have any kind of doubt, you can simply reach out in this Telegram channel as well. Now guys, without wasting any more further time, you can see on your screen the MCQs question as well. So I am giving you just guys, you can see right now we have a case studies, and this case study is based on what, sir? This case study is saying Mr. A. We have the 3 person. The first is Mr. A, Mr. B and the Mr. C. These all are partners in a after the transfer. Mr. X approaches the firm demanding to participate in the decision making and management activity. However, the other partners Mr. A and C, they all are worrying about the decision of Mr. X. So generally what happened, guys, we have the 3 partners, and in these 3 partners, the one of the partner has taken a decision. One of the partner has taken a decision for the purpose of transferring his entire interest in this partnership firm. Now the other partners is not be sure that one of the partner Mr. B has taken a decision to transfer his share of interest in the firm to the Mr. X. Now the other partners are worrying about right now, is it the Mr. B have the power to transfer of this share of interest or not? This is entire your case studies, and on the basis of MCQs. You have a first MCQs on your screen. Please read this question and let me know what is the correct answer of this particular question. Now, what a right that actually the Mr. B has in relation to what? In relation to your Mr. X, right, in relation to the Mr. B's share of interest. The first is right to interfere in the business management, right to make business decision, right to receive the share of profit, or right to control the firm's asset. Let's take example what happened in this case study. Now we have the three of the partner and the one of the partner, Mr. X. This partner has taken a decision to transfer his entire interest. So basically he transfer his entire interest to the Mr. X, the business. So the first is, let's take the example, if the partner B has the 20% of the right in this partner, he's transfer the 20%. The partnership firm is right now dissolved. So what is the Mr. X is entitled to? Yes, if let's suppose the partnership firm is going to dissolve, now what the right Mr. X is entitled to? First option, only the profits earned before the dissolution, complete control of remaining business, nothing since he was not a direct partner, and a share in the assets of the firm and verification of account, or any of the above. So can you tell me in the chat box, after the dissolution, what the right this particular partner has? Mr. X, the transferee partner, what the right he has right now? Only the profit earned in the before the dissolution. Guys, at the time when the one of the partner has transferred his entire interest to some of the other outsider person, so in such of the case, when I'm talking about, he has no any kind of right of profit earned before the dissolution. Yes, complete control of the remaining business. Sir, when I'm talking about the complete control, no, the Mr. X is a transferee partner and he has no any kind of complete control of the business. Nothing since he has not a director partner. No sir, he is eligible, he is definitely eligible to get a percentage of profit to the what extent one of the partner has transferred his interest, and a share in the asset of the firm and verification of the account. That's absolutely correct. So Mr. X has a right to share in the assets of firm and verification of account. In order to ensure that the right distribution of the profit and the right distribution of the assets will also be get to Mr. X, and for that purpose he has a right to verify the accounts, he has a right to take part in the assets of the firm as well. That's why the reason option number D is absolutely be correct right now. So would the Mr. X, what should Mr. X do if he want to participate actively in the firm management? So now this question is entirely based upon your transferee interest. When one of the partner has transferred the interest, so what the right that transferee partner is getting right now? So now the question is based upon, let's suppose Mr. X want to become the active member of the partnership firm. He want to participate actively in the partnership firm management. Now what happened in this case and how it is possible? So he can become direct partner by the consent of other partner, file a petition to claim a management right, negotiate a new partnership agreement, invest more capital to the firm, and the final option is B and C, both are the correct option. So when I'm talking about, in case when one of the partner has the right to participate in the management, and the same right a transferee partner wants to in the management of the partnership firm, so in that case he has to become a direct partner. So because the participating in the firm management is the right only given to a normal partner, it's not be given to a transferee partner. That's why the reason, if we want to become a regular partner and if we want to become a specifically member in the actively partnership management, so for that purpose he is required to get a normal partner, and for that purpose, if other partner has given the consent, he can definitely enter into the partnership as well. Now we have the next case study, and this case study is based upon I think it's an expulsion of the partner. So please read this case study and let me know what is the correct answer of this question as well. I am giving you first of all 60 seconds of the time. So kindly read the question and then we will move forward to the next MCQs over here. Yes, everyone. Have you read the entire case study? If yes, then I am also be reading for all of you. Now just focus on your case study. We have Mr. Kapoor. We have Mr. Kapoor. We have Mr. Mehta and we have Mr. Sharma. These three persons are partner in a construction firm which named is Build Smart Construction. One day, Mr. Sharma decided to retire from the partnership as the partnership at will. So you know very well we have a different type of partnership. One is partnership at will, one is general partnership, particular partnership or partnership for a fixed time period. Now this is the partnership at what? Whatsoever the partnership they have, it is basically a partnership is at will. However, before his retirement is publicly announced Mr. Mehta. Mr. Mehta unaware about the Sharma retirement and signs a contract on behalf of the firm with a supplier because Mr. Mehta is totally unaware about the Sharma retirement and on the behalf of firm he entered into one of the contract with one of the supplier. Now supplier later claims the payment from all the three partner. But guys, you can see here one of the partner, that is Mr. Sharma, has already taken a decision to retire from the partnership firm and the partnership is partnership as at will. But right now one of the partner, Mr. Mehta, is unaware about the Sharma retirement and signs a contract on behalf of all three partner, and in this case the supplier later claimed that the payment from all the three partner including the Mr. Sharma. Now to avoid the similar confusion in the future, Mr. Kapoor and Mr. Mehta, so that the same thing will not happen, for that purpose Mr. Kapoor and the Mr. Mehta, who is an existing partner in this partnership firm, they published basically a public notice about the Sharma retirement in the local newspaper and also informed the major clients. A few months later, the firm faces the challenges when Mr. Mehta accuses Mr. Kapoor for the misconducted and decided to expel him. The partnership agreement allow the expulsion for a partner if they found accused of the misconduct. So guys, we have the three situations in this entire case study. The first situation on your screen, when a one partner has taken a decision to take a retirement from this partnership firm. The second situation is one of the partner has entered into a one-off contract with the outsider and he didn't know whether the one of the partner has already taken a retirement from his partnership firm or not. And the third situation is, for avoiding the future discrepancy, they have decided to give a public notice about the retirement of Sharma. And right now the fourth situation in this case study is, one of the partner, because of his misconduct, one of the partner has taken a decision to expel him. So these are the four situations that actually covered in this particular case study. Now the question number 5 is talking about how did Mr. Sharma retire from the partnership firm. So how did Mr. Sharma retire from partnership firm? The first option, by obtaining consent from all the partner, by mutual agreement, by resigning without notice, by obtaining permission from registrar of firm, and by giving a written notice to all the partners. So can you tell me in the chat box how basically one of the partner can retire, take a retirement from the partnership firm? Yes, everyone, please do participate in the chat box, guys. If you will participate, yes, it ultimately clear out all the concepts as well. Guys, when I'm talking about, because the partnership is what? Right now we have the partnership at will. We have the partnership at will and one of the partner taken a decision to retire from this partnership firm. So in case of partnership at will firm, he just required to give a notice. So any of the partner who want to retire from the partnership firm, so that partner who has taken a decision of the retirement, so he just required to give a notice. So at the time of retirement, he is required to give a notice to all the existing partner. To all existing partner. This is the first scenario, but we have the second scenario as well. It is not sufficient to give notice to existing partner. It is also be important that you must give a notice to the public as well. Because right now the Sharma has fulfilled the first condition, but what about the second? So on this second conditions, we have a next question, but right now what is the correct answer? if he want to take a retirement from a partnership firm, he has to give a written notice to all the existing partner. Only then their retirement will be considered as a valid. Now we have the question number 6. The question number 6 on your screen, and Mr. Sharma, now the question is saying, is Mr. Sharma is liable for the contract signed by Mr. Mehta before the public notice of the retirement? You know very well that whenever a partner who has taken a decision, when a partner has taken a decision for the purpose of retirement, yes, when a partner has taken a decision for the purpose of retirement, he is required to fulfill two conditions. And what is the two conditions, sir? The first condition is given a notice to the existing partner, and the second condition is give a notice to the public as well. So notice to existing partner and the notice to the public. This is the two important requirement that the retiring partner is required to fulfill. But can I say right now this retiring partner has fulfilled the first condition but not the second one? So now the question in the case study, you know very well that one of the partner, Mr. Mehta, enter a contract with the outsider without knowing the fact that Mr. Sharma has already taken a retirement from our partnership firm. Now the question is the Mr. Sharma be liable? Definitely yes. So yes, because he was still a partner when the contract was made? No. Yes, because the public notice was not given at the time of contract. That is the main point. Because you have not been given a public notice at the time of retirement, for that purpose, you are also still liable to all the outsider till you have not been given the public notice. That's why the reason option number D is the correct answer. Now, the question is, who is responsible for giving the public notice? Is the retiring partner is responsible to give a public notice? Is the existing partners are required to give the public notice? Now the question is, who is responsible? So the first option is retiring partner, remaining partner, either A or B, A or C, the third party involved, and both B and D. So can you tell me in the chat box who has a authority, who has responsibility to give a public notice about the retirement of one of the partner? Guys, in such of the case, when I'm talking about who is responsible, so generally retiring partner as well as your remaining partner, both the partners are totally be responsible. So either the retiring partner can give a public notice, or the second one, either the remaining partners can give the public notice. The requirement is just to give a public notice. It doesn't matter who is giving a public notice. The only requirement is that the retiring partner or the existing partner must inform about the retirement of one of the partner to the public, because public is unaware about the fact that one of the partner has taken a decision to retire from the partnership firm, and for that purpose you have to inform to all the public. Now we have the question number 8. This question number 8 is talking about, can a partner be expelled from a partnership firm? Now this is the very important question. You can expect a question from your exam. Now, what circumstances can a partner be expelled from a firm? So by any one partner with a notice, by majority of the partners' consent, automatically upon breach of the agreement, by the court order only, and by all the partners' consent. So if you have read the case study now, so in the last fourth situation, you may find a particular point that one of the partner has done some of the misconduct. For that purpose, one of the partner has taken a decision to expel him. Expel means remove him from the partnership firm, the person who committed some of the wrongful act. Now the question is saying, at what circumstances a partner can be expelled from a partnership firm? So guys, a partner can be expelled from a partnership firm by majority of the partners' consent. If there is a majority of the partners' consent, only then a partner shall be expelled from the partnership firm, otherwise not. So option number B is absolutely the correct answer, guys. Now we are moving forward to the next case study, and this case study is again very important from your exam point of view. First of all, I am giving you 35 to 40 seconds of the time. Please try to read this case study by your own, and then I will read the entire case studies, as well as I will cover your all the probable type of question that is based upon this particular case studies. So now, first of all, read the entire case studies. Now your time has started right now. Guys, now I'm reading this entire case studies, and yes, then we will cover the MCQs as well. So the case study is Elite Trader. Elite Trader is a what? Elite Trader is a partnership firm formed by Mr. Rao, Mr. Gupta and Mr. Singh. So basically we have the three of the partner, Mr. Rao, Mr. Gupta and Mr. Singh. They decided not to draft a partnership deed. So they have the very mutual understanding, and for that purpose they have decided not to draft any kind of partnership deed as they had the strong mutual understanding. As a result, the firm remained unregistered. So this is the one of the hint under this case study, that one of the partnership firm is totally unregistered. Now after a few months of profitable business, after a few months of the profitable business, a dispute arose between Mr. Gupta and Mr. Singh regarding the distribution of the profit. Now guys, partnership firm is totally unregistered, and we have a situation that two of the partner have a dispute related to the distribution of the profit. Now Mr. Singh claimed that he was entitled to larger share based upon his investment, but Mr. Gupta refused to acknowledge this. Mr. Singh want to file a lawsuit to settle the issue, but his legal lawyer advised him that filing a suit against the firm. So what happened now in the second situation? In the second situation, Mr. Gupta refuses to acknowledge this, and for that purpose Mr. Singh want to file a lawsuit to settle this particular matter, but his lawyer advised him that filing a suit against the firm is the quite feasible option. Now we have the third situation. The third situation is around the same time the firm enter into a contract. The firm enter into a contract with the supplier named ABC Limited in order to purchase the goods for the worth of rupees 5 lakh. However, ABC Private Limited failed to deliver the order goods, causing a significantly loss to the Elite Trader. So guys, again we have the three situations. The first situation is in an unregistered firm, there is a dispute between Mr. Gupta and the Mr. Singh. There is a second situation. The second situation is what? Right now one of the partner is demanding the higher share and the other partner is objecting this share, and definitely he want to file a lawsuit against the partnership firm. And the third situation is right now we have the firm has basically entered into one of the contract with the supplier named ABC Private Limited for the worth of rupees 5 lakh. However, ABC Private Limited failed to deliver the order goods, causing significant loss to the Elite Trader. Now the Elite Trader want to sue the supplier for the breach of contract. Now realizing the limitation and legal disadvantage, so we have a very good clarity about which particular concept this case study is based on. So yes, this case study is based upon your unregistered firm obligation and the legal limitations. Now the partner decided to register the firm, but on the basis of this case studies, the first of all question on your screen is question number 9. Under which section of the Partnership Act are legally disability of an unregistered firm mentioned? So now can you tell me in the chat box which section? Sir, section 69 of Indian Partnership Act. That's great. So which section is explaining the legal disability of the unregistered firm? So your section 69. Why, sir? Because when I'm talking about the section 69 of Indian Partnership Act now, the section 69 of Indian Partnership Act clearly prescribing that registration of partnership firm is totally optional. It's what? It's totally optional. It's not a mandatory. If any partnership firm want to register, yes, definitely he can. But if any of the partnership firm, if they are not be registering now, they have some of the legal disabilities, and that disability is prescribed under section 69. Now we have the question number 10 on your screen. This question number 10 is saying, what major legal drawback did Elite Trader face as an unregistered firm? So what is the legal disabilities? What is the legal drawback that this unregistered firm face in this particular case study? The first option is the firm cannot pay taxes, the firm cannot sue the third party, the firm cannot open a bank account, the firm cannot enter into with the contract with the third party, and the firm cannot sue third party for the value exceeding 100 rupees. So please let me know in the chat box which option is absolutely correct in this particular case studies. Yes guys, when I'm talking about the major disadvantage for non-registering of partnership firm is that the firm cannot file a suit to the third party if the value is exceeding 100 rupees. Yes, they may file a suit, but the value is not be exceeding the 100 rupees. Only then they can file a suit. Otherwise, for the value exceeding 100 rupees, they are not able to file the suit against the third party. Now, in this case study, you can see they have the contract of 5 lakh and the 5 lakh value is exceeding the 100 rupees. That's why the reason this partnership being an unregistered firm not able to file a suit against the third party. Now we have the question number 11. The question number 11 is talking about which of the following is not a consequences faced by an unregistered partnership firm. So now you all are required to tell me in the chat box which of the following is not a consequences. It means it's an advantage for a partnership firm if they are not registered under the Indian Partnership Act. The first option is unable to sue the third party, can be sued by the third party, partner can sue for a dissolution of the firm, no relief for set of claim 100 rupees, can freely file suit against its own partner. Now please tell me in the chat box what is the correct answer of this particular case. Guys, when I'm talking about the unregistered firm now, so the unregistered firm have some of the limitation, and the first limitation is they cannot file suit against the third party. They cannot file suit for the value exceeding 100 rupees against what? Against the third party. The second is partner cannot file suit against the another partner. If one of the partner, if they want to lodge a suit against the other partner, yes, they are not able to file a suit against the other partner. The third provision is if the partner want to file a suit for the dissolution of partnership firm, so this is the right has given to the partner. Yes, the partner has a right to file a suit for the dissolution, but they didn't have the power to file a suit against the other partner. They didn't have the power to file a suit against the partnership firm. So these are the limitation, but they have a power, they have a right to file a suit of the dissolution against the partnership firm. So can I say the option number C is the correct answer? Yes, of course. Now I am moving forward to the question number 12. Question number 12 is deal with what legal advices did Mr. Singh receive when he want to file a lawsuit for a higher profit of share. So can you tell me in the chat box what legal advices did the Mr. Singh receive when he wanted to file a lawsuit for a higher profit of share? Guys, you know very well, when one of the partner want to file a suit for the higher profit of the share against the partnership firm, against the partner, so they are totally not allowed. Why, sir? Because the partnership is totally unregistered. So what will be the correct answer, sir? In this case study, in this question, we have the correct answer is he could not file the lawsuit because the firm is totally unregistered, and the unregistered firm cannot file a suit against the partner, and definitely in such of the case, unregistered firm has not a power to file a suit. That's why the reason this is the correct answer. So the option number D, if you are selecting, yes, of course, your answer is correct. Now guys, we are moving forward to the next case study, and this case study is based upon a contract with minor. A contract with minor, this case study is totally based on. We have XYZ and company. This XYZ company is a partnership firm which basically engaged in the garment manufacturing businesses. Now, the firm has 3 partners, partner Raj, partner Sanjay and partner Meera. So this particular partnership firm has 3 partners, Raj, Sanjay and Meera. Raj's nephew Rohit, who is only 17-year-old, is interested to being the part of partnership firm. After discussing among themselves, the partner decided to admit the Rohit to the benefits of the partnership firm. So this is the first situation in this case study. Now, the Rohit enjoy the benefit of partnership, including a share of profit and access to the partnership firm account. However, he is not personally liable for any debt liability arising from the partnership firm. Okay. Now, upon attaining the age of majority, now this minor become the major. Now, upon attaining the age of majority, now Rohit contemplated that whether to continue. Now the Rohit want to know whether to continue as a full-fledged partner or opt out from this. Now after this 6 month, Rohit has taken a decision. Sorry, after 6 months after turning the 18, Rohit basically fails to give a public notice of his decision whether he want to become a partner in this partnership firm or not. As a result, what will be his liability in the partnership firm? So can I say this is the second situation in this case study? Yes, sir. Now, suppose we have the another situation. Another scenario, Rohit decided to give public notice that he does not wish to become a partner. As a result, what will be liability in this partnership firm? Can I say this will become a third scenario in this particular case study? So in this case study, we have the three scenario. The first scenario is one of the partner has given a proposal in the partnership firm for the purpose of admission of one of his nephew whose age is only 17 years into the benefits of the partnership. The second is, right now, after attaining the majority, the minor child has basically not been given any kind of notice to the public for the purpose of becoming or opting the partner or not in the partnership firm. And the third situation is, let's suppose they have given a notice, then what will be his liability in this partnership firm? Now, first of all, I am moving to the question number 13. The question number 13 is saying, which section of Indian Partnership Act 1872 is a minor declare incompetent person to enter into a contract? So can you tell me in the chat box which particular section prescribing that a minor is totally incompetent person to enter into a contract? Have you remembered the Indian Contract Act section 10? Yes, na? The section 10 is talking about the essential feature in order to make a contract valid. Now, you know very well, minor is an incompetent person. Minor is a what? Minor is an incompetent person. So can he enter into a contract? No, sir. Because when he enter into any of the contract, their contract with any of the party become void ab initio. Because any of the contract with the minor is totally remain void ab initio. So if one of the person whose age not exceed 18 years and he want to enter into a contract with the other person, so in such of the case, the contract with the minor is totally void ab initio. And the second situation, partnership is a what? When I'm talking about how the partnership can form through the contract. Partnership can form through the contract. That's for the reason Indian Partnership 1932 is required to fulfill all the conditions prescribed under section 10 of Indian Contract Act 1872 as well. Because partnership can be formed as a way of oral, partnership can be formed as a way of written. From any of the way partnership can be formed, but after fulfilling all the conditions prescribed under section 10 of Indian Contract Act. And right now the minor is not a competent person, so he is not be eligible to enter into a contract, as well as he cannot become a partner into this partnership firm. Now we have the question number 14, and the question number 14 is talking about right now, how can a minor be associated with the partnership firm? How can a minor associated with the partnership firm? Now one of the partner who want minor to be admitted into the benefits of the partnership, so now it will possible. What is the way that we can possible the admission of any of the minor? Now the first situation is, as a full partner you can admit the minor into the benefits of partnership. No sir, minor cannot become a partner. It's a very simple. Minor cannot become partner. Why sir minor cannot become a partner? The reason is very simple. He is an incompetent person. Minor can become as a dormant and associated with the partnership firm. No, dormant partner is again required to fulfill the condition under section 10 of Indian Contract Act. A partner with a limited liability, no, limited liability concept is only be applicable in case of company or in case of LLP. Admitted to the benefits of partnership with the consent of all partner, admitted to the benefits of partnership with the majority consent of the partner. Now I can say here the correct answer is option number D. If all the partner has given a consent that yes, we are giving a permission to enter one of the manner into the benefits of the partnership now, only with the full consent, only with the consent of all partner, this quite be possible. That's why the reason option number D is absolutely the correct answer. Now we have the question number 15. And what does the question number 15 is talking about, guys? This question number 15 is talking about right now what happened. What happened if a minor, after attaining a majority but fails to give a public notice of his decision within a 6 month? Now, the question number 15 is talking about, let's suppose one of the minor, after attaining a majority, fails to give a public notice of his decision within a 6 month, then what we will assume? He is automatically become the full partner. The second is, he loses his share in the partnership firm. He remain minor partner indefinitely. His liability remains same as a minor, and he excluded to become a partner in that partnership firm. Yes, what exactly the correct answer of this particular question? Please let me know in the chat box. Yes, so the correct answer is what? Right now we have the correct answer, that is he is automatically become the full partner. When one of the person who is a minor, after attaining the majority, he is required to give a public notice about his decision whether he want to become a partner in the partnership firm or not. If he has opted to become a partner in the partnership firm, then yes, he has to give a public notice and want to confirm that he want to become a partner in the partnership firm. But in case he didn't give any kind of notice to the public within a 6 month, so he will automatically become a full partner in the partnership firm. Now, the next question, we have the question number 16. If a minor partner elects not to become a full partner after attaining a majority, what is liability for act done by after the public notice? Now guys, it's a very important. This question is again very important because the question is talking about, let's suppose the partner has taken a decision not to become a full partner after attaining a majority. Now what will be his liability for the act done by firm after the public notice? So once the minor has given a notice to the public that he has taken a decision not to become a partner into the partnership firm, so definitely he is not be liable. He is not be liable for any act done after his notice. He just required to give a notice to the public, and after giving a notice to the public, his share is not be liable from the date of publishing the notice to the public over here. That's why the reason option number C is quite absolutely correct answer in this particular question. Now we moved on the question number 17. Question number 17 is talking about what is the status of minor share in the partnership property and profit if he choose not to become a full partner after attaining a majority. Let's suppose one of the partner who has taken a decision that yes, I not want to become a partner in this partnership firm after attaining a majority. Now what exactly the status of his minor share and the partnership property over here? So the first statement is his share is forfeited, his share remain as it was during his minority, his share is redistributed among the other partner, and he received the additional compensation. Yes guys, what happened afterward? What is the status of minor share in the partnership property and profit if he choose not to become a full partner? So his share, when one of the partner has taken a decision that I will not want to become a particular partner in the partnership firm after attaining a majority, his share will be forfeited, because right now he is not be eligible to become a partner. He has given a notice to the public that he don't want to become a partner in the partnership firm, so his share will be forfeited, but he is eligible to get up to the date of notice of all the profit, all the property for which he was admitted as a benefits of the partnership firm. Now we have the question number 18. The question number 18 is talking about when can a minor sue the partner for his share of property or profit according to Indian Partnership Act 1932? The question number 18 is talking about when can a minor sue the partner for his share of property or profit according to Indian Partnership Act? At any time during his minority, after attaining majority irrespective of the notice, only when severing his connection with the firm, immediately after being admitted to the benefits of the partnership firm. So yes, when the minor has severed from the connection from the partnership firm, yes, after that he is eligible to sue the remaining partner for his share or property for which he is admitted to the benefits of the partnership. So can I say right now, only when severing his connection with the partnership firm, he is eligible to claim his particular share of property or share of the profit? Definitely yes. Now we have the question number 19. The question number 19 is, what are the liabilities of minor partner after becoming a full partner due to the failure to give public notice within a 6 month? You know very well, if one of the minor who didn't give any kind of notice within a 6 month after attaining the majority, so he will automatically become a partner in the partnership firm. Now the question is, for the what amount he is liable to the partnership firm? The first option is liable only up to the future act after majority, not personally liable at all, liable only for the acts done after giving a public notice, liability arise only with the consent of all the partner, and liable for all the act done since admission to the benefits of partnership firm. So what is the correct answer of this question? Please let me know in the chat box. Yes, what is the correct answer? Definitely option E is the correct answer. Why sir option E is correct? When a one partner after becoming a full-fledged partner due to the XYZ reason, either he has not been given a public notice within a 6 month or either he opt to become a partner, so his all the act for the partnership firm done since the admission to the benefits, he will be liable. So when the minor was admitted to the benefits of the partnership firm now, from that date all the obligation of partnership firm, he will be liable at all. So that's the reason when I'm talking about one of the person who has taken a decision opt to become a partner, so this two of the point I'm covering here, so that any of the point you can expect a question in your exam. So minor opt to become a partner. When minor opt to become a partner, so his liability for all his share, so he is liable from the date of admission, and one of the minor when not opt to become partner, in such of the case his share will be liable up to the date of notice. So till the minor has not been given a notice to the public that he is not opting to become a partner in the partnership firm, so till that notice his share is liable to the public over here. So in this case, because right now the minor has taken a decision to become a partner or basically not be given a notice within a 6 months, so he deemed to become a partner in the partnership firm, so his share will be liable for all the act since from the date of admission to the benefits. Now this is the Telegram channel where you can ask any of the questions, and because all the questions are based upon your concepts, so make sure for a conceptual coverage you can watch all the SEBI Grade A complete course, because each and every question is based upon your concepts. If your concepts are strong, definitely everything is doable, but if your concepts are not strong, you will not able to solve any of the question. And for any kind of doubt, you can simply be asked in this Telegram channel as well. Now I am moving forward to the next case study. And this case study is again a very important case study because it deals with your implied authority or express authority of a partner. First of all, read this question by your own, and then I will read the entire case studies and we will definitely solve, after reading this case study, lots of the important MCQs which is based upon this case study only. Now your time has started right now. Please read the case studies right now. Guys, case study is based on this case study is based on Zenith Trader. Zenith Trader is a grocery trading firm operated as a partnership between Mr. Arjun, Mr. Ravi and Mrs. Saneha. So generally Mr. Arun, Mr. Ravi, Mrs. Saneha, these three of the partners we have right now in this partnership firm of Zenith Trader. Now the partner have always followed an informal decision making process, and each partner assume they have the implied authority to act on behalf of the partnership firm. Recently, we faced some of the disputes arose regarding the action of individual partner. And what is that dispute right now we have? The first is Mr. Arjun purchased a large stock of groceries. Mr. Arjun purchased a large stocks of groceries without consulting with other partner. The purchase was essential for the business, but Mrs. Saneha objected by saying that he need prior approval before purchasing such a large stock of groceries. The second situation we have right now, Mr. Ravi, who borrowed 10 lakh rupees from a local money lender in the name of Zenith Trader to cover a temporary shortfall. The other partner were unaware of this borrowing. So the second situation is one of the partner borrowed 10 lakh rupees from the money lender in the name of Zenith Trader, but other partner is unaware about this borrowing. We have the third situation, Mrs. Sneha withdraw a lawsuit. So generally Mrs. Sneha, she is a partner in the partnership firm and withdraw a lawsuit that a firm filed against a supplier for the breach of contract. Now the other partners argue that she had no authority to do so. So how she can withdraw the lawsuit which filed against the firm? Now Mr. Ravi, who attempted to open a bank account in the firm name, but bank requested the proof that he had authority to do so or not. Now without consulting with the other partner, Mr. Arjun enter into a new partnership agreement with another partner, claiming it would benefit to the Zenith Trader. Now the partner seek the legal advices. Now the partner want a legal advices on whether this action fall within the implied authority of the partner as per Indian Partnership Act 1932 or not. Guys, when I'm talking about the partner's authority now, so generally partners have two type of authority. And what the type of authority we have? The first is implied authority and the second is express authority. When any kind of authority has given to partner expressly, it comes under the express authority. But any kind of act which presumed by law as an authority of the partner, so it's become a implied authority of partner. So when I'm talking about the implied partner's authority, so basically it's presumed by what? It's presumed by law. But the law will presume only those authority which exercise in the ordinary course of business. So only those authority which exercise in the ordinary course of business, only then, even though the partner didn't have the express authority, but that particular act will remain valid into the partnership firm. But implied authority is always be presumed by law, but that authority must be exercisable. That authority must be exercisable in the ordinary course of business. If one of the partner has exercised any of the authority in the ordinary course of business, that particular authority is valid, otherwise not. You can take the example of, let's suppose Oliveboard is a partnership firm. I am one of the partner of Oliveboard. But let's suppose I have entered one of the contract for the purpose of selling the immovable property of the partnership firm. Can I sell the immoral property of the Oliveboard being a partnership firm, being a partner in the partnership firm? No sir. Why? Because my usual course of business is giving a service to all the aspirants, but this is not my ordinary course of business. So that's all about the concept of your implied and the express authority. Now back to the question number 20. The question number 20 is talking about right now, which following actions of Mr. Arjun falls within his implied authority. So right now tell me in the chat box which particular act performed by one of the partner falls under the definition of implied authority. At the time when you are giving an answer, always be keep in your mind that particular act always in the ordinary course of business. If any of the act of the partner within the ordinary course of the business, definitely we can say he has a implied authority for exercising this right, and definitely for that purpose the partnership firm will be liable. Now, purchasing the grocery stock from the firm, opening a bank account in the firm's name. Now the question is, if one of the partner want to open a bank account in the firm name, can I say it's a regular and ordinary course of business of the partner? Selling the firm immoral property without the consent, can I say it's an ordinary course of the business of the partner? Entering a partnership with another firm on behalf of junior trader, can I say it's a ordinary course of the business of the partner? No sir. So in this case, only the option number A is the correct answer. Why sir option number A is correct? Because when I am talking about the ordinary course of business of the partner now, it means when you are buying, let's suppose because in this case studies we have the partnership firm who is a trading partnership firm. So purchasing of goods, selling of goods, receiving a money from the debtor, advancing a money, these are considered under the ordinary course of business, and the remaining one is not be considered the ordinary course of business. If you are performing this act, you need a proper approval from the partnership firm. Now we have the question number 21. Did Mr. Ravi have the implied authority to borrow 10 lakh rupees on behalf of the junior trader? So this question number 21 is again very important. This question number 21 is talking about, did the Mr. Ravi have the implied authority to borrow 10 lakh on behalf of the junior trader or not? Yes, the borrowing money for the business is a part of implied authority. No, a partner can never borrow on behalf of the firm. Yes, but only if the loan is used for a personal expense. No, borrowing money is not only allowed if the partnership did explicitly be permit. Guys, here we have the correct answer of option number A. Yes, the borrowing money for a business is the part of implied authority. Yes, and because it's the part of ordinary course of business. Now, one of the partner in a partnership firm, I have the right to borrow for the special purpose of the partnership firm. And if I am borrowing, it will fall under the implied authority. But if I am borrowing for my own personal use, it actually comes under the express authority if I obtain the loan and if I borrow the money from the outsider in the name of firm, but I am utilizing the money for my own personal purpose. So this required an express authority, but right now the borrowing money for the business purpose, it will consider the implied authority because it comes under the definition of ordinary course of business. Now we have the question number 22. Question number 22 is talking about, which of the following action of Mrs. Saneha was not within the implied authority? So which of the following action of Mrs. Saneha was not within her implied authority? Hiring a lawyer to defend a firm in a court, withdrawing a lawsuit that the firm had filed, settling the accounts with supplier, receiving a payment from the customer. So option number B is correct answer. Withdrawing a lawsuit that the firm had filed. So generally option number B is the correct answer. Implied authority is not be giving you the extraordinary activity or extraordinary right. This is an extraordinary right. If any of the firm is filed a case against any of the third party, so the firm has a right to withdraw the suit, not any of the partner. That's why the reason option number B is the correct answer. Now the question number 23 is talking about, why was Mr. Ravi unable to open a bank account in the name of Zenith Trader? Guys, opening a bank account, it's not with the part of implied authority. if you want to open any of the bank account in the name of Jina Trader, now you need a express authority from the existing partner and from the partnership firm. If the partnership firm is permitting you that you can open accounts in the name of the partnership firm, only it is allowed, but this is not the ordinary course of business. That's by the reason partner does not have the implied authority to open a bank account for the partnership firm. So can I say option number C is the absolutely correct answer? Yes, sir. Now we have the question number 24. This question is talking about Mr. Arun enter into a partnership firm agreement on behalf of Jina Trader without consent of the other partner. Now the question is saying, is it he has a right to enter on the behalf of partnership firm into any of the new partnership agreement? The option 1 is yes, entering into partnership it's a part of implied authority. The second option is yes, but only if the new partnership is the same line of business. No, unless the partnership have 2/3 consent from the other partner, and no, the partners do not have implied authority to enter into a new partnership on behalf of the firm, and no, unless the partnership have 3/4 consent from the other partner. Guys, if one of the partner want to enter into a new partnership agreement on behalf of Jina Trader, and for that purpose he required express authority, because it also not covering under the implied authority of a partnership firm. So can I say right now, is it a partner has a power or authority specifically to enter into any kind of partnership agreement on behalf of the firm? No, sir. Because for entering into the partnership agreement on behalf of the firm, it required express authority. And because you don't have the express authority, you cannot enter into the agreements over here. Now we have the question number 25. Now you can read this question number 25. And please let me know in the chat box what is the correct answer over here. Kindly read the question number 25 and let me know the correct answer. The question number 25 is talking about what matter require a notice to registrar of firm under section 63 and public notice by publication in the official gazette and it at least one of the vernacular newspaper circulating in the district where the firm to which it's relate has its place or principal place of business. So the question is based upon what matter required. Which of the following incident occur the given notice to the partnership registrar of the partnership firm? So in which of the following circumstances a partnership firm or a partners are required to give a notice to the registrar of firm? The first is dissolution of the register of the firm, retirement or expulsion of the partnership from the registered firm, election to become or not to become a partner in a registered firm by a partner attaining majority who has admitted as a benefits to the benefits of the partnership. All of the above, or there is a no notice required. Guys, when I'm talking about the given a notice now, if you want to dissolve a registered partnership, yes, you required to give a public notice, and that notice given a public into the vernacular newspaper or English newspaper. The second is retirement or expulsion. If specifically when I'm talking about if any of the partner who's taken a retirement from the partnership firm, he is required to give a notice as a way of public in two of the publication. One is a vernacular, second one is English newspaper. And when one of the minor child after attaining a majority, he decided to become a partner in the partnership firm, again he is required to give a public notice. So in all of the above circumstances, this particular partners are required to give a notice, publicly notice to the publicly notice in the one of the newspaper, that is vernacular newspaper or English newspaper. So option D is the correct answer. Now I am moving forward to the question number 26. The question number 26 is talking about the contract of sale. There is a implied warranty, and the implied warranty is what? You know very well, when I am talking about in any of the contract of sale, we have some of the stipulation, and that stipulation may be in the form of your condition, or that stipulation may be in the form of for your warranty. So the stipulation may be in the form of condition, the stipulation may be in the form of warranty. We have the two type of condition and the warranty. The first is your implied condition and the implied warranty, and we have the express condition and the express warranty. When any of the condition and warranty actually enter expressly, it's become express condition and the warranty. But When the law presume some of the condition, some of the warranty, so it comes under the implied warranty over here. So seller has a right to sell the goods. The buyer has right to have enjoy the quiet possession of the goods. The goods shall be free from any charge or encumbrance, and the buyer has right to have enjoy the quiet possession and the goods has been free from any charge or encumbrance. Guys, this is the option number D. Option number D is the correct answer, because in these circumstances only this option is perfectly be matching with the implied warranty. Buyer has a right to have enjoy the quiet possession of the goods and the goods shall be free from any kind of charge or encumbrance. What is condition, sir? Condition is essential purpose of the contract. What is warranty? Warranty is a collateral to the main purpose of the contract. The breach of condition you can claim for, you can definitely repudiate the contract, cancel the contract. But breach of warranty, you can just claim the damages over here. And all these concepts we have already be covered in your complete course of SEBI Grade A. So if you want to enroll, you can just download the application of Oliveboard and check it out this conceptual classes as well. Apart from it, if you have any kind of doubt, you can simply reach out in my official Telegram channel, Chartered Ajay Thakral. Now I am moving forward to the question number 27. This question number 27 is talking about what is the dissolution of partnership form. What is the dissolution of partnership form? Yes, everyone. When I'm talking about the dissolution of partnership firm now, so dissolution is consist with your two type. The dissolution it's consist with your two type. One is a dissolution of firm and the another one is dissolution of partnership. When I'm talking about the dissolution of partnership, it's just like a reconstitution of the firm. It is what? It's a reconstitution of firm. It's a reconstitution of firm. But the business relationship does not be end in case of dissolution of partnership. But when I'm talking about the dissolution of partnership firm, it means the business relation comes to end. Business relation comes to an end. Like you can take the example of admission of one of the partner. Admit of Mr. A as a partner in the partnership firm. So initially we have the two partner B or C, and right now we have admitted Mr. A as a partner in the partnership firm. So it's a reconstitution of the firm. So it means what? It means the reconstitution of the firm, that is the option number A. Reconstitution means we have the three of the partner. We have partner A, partner B and the partner C. The partner C has taken a decision for the purpose of retirement. But right now the business relationship has not ended in this partnership firm. Partner A and the partner B has taken a decision to continue this business of partnership firm. So it will come under the dissolution of partnership firm over here. Now we have the question number 28. So please read the question number 28 and let me know the correct answer as well. Have you read the question? Guys, the question is saying after a partner's death, business is continued in the old firm name. After the partner's death, the business is continued in the old partnership name. Whether the legal heirs of deceased partner are liable for any act of the firm or not. Now, after the death of one of the partner, the business is continuing in the old name. Now the question is the legal heir is liable for all the acts of the partnership firm after the decease of one of the partner? Now the first option. The continued use of the name or deceased partner name as a part thereof shall not itself make his legal representative or his estate liable for any act of the firm done after his death. The second is, if the estate of deceased partner's property is insufficient to make good the personal asset of the legal heir will be liable for any act done by the partnership firm. The state of deceased partner is liable for any of the act done by the partnership firm. The legal heir of deceased partner shall be liable for any act done after the demise of the partner, and the state of deceased partner is not liable for any act done by the partnership firm. Guys, when I am seeing here, at the time of death of one of the partner, yes, the legal representative is not be liable. The legal representative is liable only up to the part when the partner was surviving, when the partner was the part of partnership firm. But after the decease or demise of one of the partner, if partnership firm is continuing with the old name, so it means the partners and the deceased partner legal representative is totally not liable for any of the act done after the death of the partner. So the continued use of the firm or deceased partner name as a part of thereof shall not itself make his legal representative or his estate liable for any act after his death. So option A is the correct answer. Now I am moving forward to the question number 29. Kindly read this question and let me know what is the correct answer as well. Guys, this question is saying, when a partner has in any way transferred the whole of his interest in a firm to the third party, we have already covered this type of question, or has allowed his share to charge under the provision of first schedule to the Code of Civil Procedure, or has allowed it to be sold in the recovery of arrear in the land revenue or any dues recoverable as a arrear of land revenue dues by the partner. So what is exactly this question is talking about? So the first is, the court may dissolve the firm at the instance of any other partner. The court may direct other partner to reconstitute the firm by excluding that concerned partner. The court may not dissolve the firm at the instance of any other partners. The court may expel the concerned partner who has done wrong before the partnership firm, and the court will take the consent from all the partners over here. Guys, right now you can see, when one of the partner has transferred the entire of his interest to the third party, in such of this scenario now, what happened now in the case when one of the partner want to be dissolve the partnership firm, so the court may consider that request. The court may dissolve the firm at the instance of any other partner. So if I am talking about the option number A, definitely the option number A is absolutely correct answer in this question. Now we have the question number 30. Again, this question is very important. It is also based upon your Partnership Act 1932. Now we are reading this question as well. We have XYZ in a partnership firm, partner X, partner Y and the partner Z. These are the three partners we have. During the course of business travel, partner X recovered the sum of 1,50,000 in cash from a debtor of the firm and credit him his personal bank account. The act of X will be amount to what? Guys, can I say one of the partner can receive the payment in the ordinary course of business, from one of the debtor? Yes, absolutely yes, sir. Any of the partner can receive any of this sum receivable from any of the debtor of the firm. Now, in this case, instead of crediting the partnership firm bank account, what he has done wrongly here, he credited in his own personal bank account. So can I say right now the Mr. X misappropriated the partnership firm fund? Yes, sir. So it's a nothing wrong? No, sir, it's a wrong. Second is, it depends upon the discretion of all the partner. It's a misappropriation of the fund of the firm and utilizing the same for the personal gain. So if any of the partner is misappropriating the fund, so for that purpose the firm is liable in such of the case, because right now he is on a not a private trip, he is on a business travel, and right now whatsoever the fund he has received from the debtor, in such of the case the firm is liable. The firm is liable to what? Firm is liable to the third party. To the third party, firm is totally liable. It will fall under the misappropriation of the fund of the firm. Now we have the next question, question number 31. This question is saying, if a partner is declared insolvent, which of the following statement shall incorrect? Again guys, it's a very important question. If one of the partner who is declared insolvent, now which option is incorrect in this 5 statement whatsoever we have? The firm may dissolve or may not dissolve in that situation. Yes sir, it's perfectly be true. If we have a 3 partner, the insolvency of the one partner will leads to dissolution of the partnership firm? No sir, because the remaining partners may continue the partnership business. So we cannot say yes, the partnership firm will definitely be dissolved. But in case when we have a 2 partner and one partner is insolvent, can I say the only one partner will not able to continue the business, and in such of the scenario the partnership firm will going to dissolve? Yes. So it's may be dissolved, it's may not be dissolved. It's correct. He ceased to be the partner of firm from the date of order of adjudication is made. Yes, absolutely. Once the court declare any of the partner insolvent, so from the date of adjudication is made, he will not associated with the partnership firm as a partner over here. That's why the reason second statement is also true. Now, the firm shall become liable for any act of the insolvent done by him after the date on which the order of adjudication is made. Wrong sir. Why sir it's a wrong? Why sir it's a wrong? Because the firm shall become liable for any act of the insolvent done by him after the date on which the order of adjudication was made. So from the date of adjudication, that insolvent partner will cease to partner in a partnership firm. For any kind of act of that insolvent partner, the partnership firm will not be liable at all. So in this case, in this third option, you can see here, the option is saying the firm shall be liable. No sir, the firm will not be liable at all in case when the date of adjudication was made. So the option number C is absolutely be incorrect option. Okay. What this question is? This question is, I think it's based upon Indian Contract Act. Again, the next question is based upon Indian Contract Act. So now we have completed the Partnership Act. Okay guys, today what we have completed? So today we have completed the majority of the question of Partnership Act. Now the remaining question is deals with your general contract. So that general contract questions we will going to cover from the next session. So that general contract type of questions we will going to cover from the next session. Yes, today we have covered almost 32 type of the questions, and if you enjoy the session, definitely don't forget to like the session and share with your friends and the colleague as well. So from the today onward, we have started one of this selection series, and that selection series helps you to practice of all the important questions, probable questions of your SEBI Grade A paper number 2 in your phase 1 examination. Yes, I'm hoping right now whatsoever the question of Partnership Act we have covered in this session is too much important for you as well, and you have definitely enjoyed the session. So if you really enjoy the session, don't forget to like the session, share with your friend, and we will meet now on the Thursday. Now in the next Thursday, because in a 1 week you have only 2 class. So on a Thursday of the class, we will definitely meet, and in the Thursday of the class, we will extend the session for 2 hours definitely, because we have to cover the contract law questions, and we have to cover the general contract and the special contract type of question and the contract of sale. So in the next class which is scheduled on Thursday, my basic agenda will be contract of sale type of question, my special type of question, special type of contract question. So that type of contract of questions we will going to cover, and your remaining special relief contract. So SRC type of questions we will also be covered in the Thursday of the class. So thank you so much for your valuable time and support. Now we will meet in the next class. Thank you so much guys. If you like the session, please click upon the thumbs up button, and definitely if you have enjoyed the session and you have definitely participated in lots of the important case studies, because my today approach is very simple to be cover each and every kind of question in a such a way so that you have the conceptual clarity as well as you have the practice of lots of important questions in this session as well. So we have covered lots of important case studies and the questions. I am hoping right now you have enjoyed the session. If you enjoy the session, like the session, and definitely you can share with your friends and the colleague. Now we will meet in the next class. Till then, take care. Thank you very much. Bye bye to all of you guys.